So a very good morning to good evening to all the viewers. Myself, Dr. Rajesh Singh, Associate Professor, Parul Institute of Law, Parul University. Warm welcome, Ms. Prachi Pratap, from the advocate from the Supreme Court of India, and she is going to elaborate on the Indian Evidence Act, which is the curriculum of our subject also, and our all the student is going to be live because this is the curriculum subject. Secondly, that I warm welcome. Let me speak. Ms. Prachi Pratap ma'am. She is an advocate and she is having a good law firm also at Supreme Court, and she is regularly practicing in the criminal and civil, as well as she also appear in the matters of banking also. So not taking more time, I really warm welcome you. Now I will tell, we have our Pro Vice Chancellor, Mr. M.N. Patel sir, who is there with us on this platform. Now I will tell Dr. M.N. Patel sir to just warm welcome our eminent speaker, Prachi Pratap. Over to you. Hello. M.N. Patel sir, I am audible to you.
I am in one program, so yeah, my best wishes to you. Please proceed because still I have not completed the previous program. Please.
Okay. So, ma'am, it is a really great pleasure to us, and we will proceed with the further program. Now, I will tell Prachi Pratap madam to just go on, not wasting the more time. So, ma'am, it is your kindness if you can go on the topic directly on the Indian Evidence Act. Over to you, ma'am.
Thank you so much, Rajesh sir, for having me here. So let's, without wasting more time, let's just start with the lecture. I'm just going to share the screen and 1 minute.
Yes, ma'am, you can share from here.
Right.
Share screen is there. You can share from here.
I'm just trying to get this 1 moment.
Yeah.
There.
Yeah, ma'am.
Yeah, it's visible, right? Yeah.
Yeah.
Okay. So, just a minute.
Ma'am, I think you can just have a PowerPoint mode. There is, so you can convert on the PowerPoint mode.
Yeah, it's.
I think
it's not.
I think over here it is.
Yeah,
just
it's. Yeah.
You can start now.
Yes, sir. So let's just begin with the basics of evidence. Let's trace where the word comes from. It starts from the word evidere, which is of Latin origin. It means to show clearly, to make plainly certain, to ascertain, to prove. So Taylor says that functional and description of court processes, the word evidence includes all legal means, exclusive of mere arguments, which tend to prove or disprove any matter of fact, the truth of which is submitted to judicial investigation. So evidence may bear two meanings or refer to means that tend to create a belief in the mind of the judge, and the final belief, which actually is created in the mind, known as proof. So both of them are basically trying to create a belief in the mind of the judge, that is evidence. Proof is the end and evidence is the means to prove. In the Indian Evidence Act 1872, the word evidence is used in the sense of means. Just a minute, I'm unable to. What? I'm having difficulty with this. 1 moment, sir. So I'm just going to go through it like this because we are having a little difficulty with this, sir. Is it visible, Rajesh, sir? Because I'm using a different system today. So you're not audible.
the first screen which you have opened is visible, but it is not going to the second screen.
Just a moment. Is it visible now, sir?
Is it visible? But there is not visibility in the entire. But you can take, madam, you can start from that.
Yeah, I'll just
Please
do
not-
that. That would be better, right?
For some technicalities, it can be understood. We can have the knowledge of the law. That's it.
Right. So let's go to the next part, which is the statutory interpretation of the Evidence Act. Rajesh, sir, I'm just going to quickly forward it to you. Perhaps you can share at your end.
Yes, you can. You can.
That
also
makes
provide
more
them.
sense.
Yeah.
Because it will be nicer if you can share it. I'll just forward it to you.
Yeah.
So did you get it?
No, ma'am.
So देखिए मिल गया होगा.
I have not received, ma'am.
Chaliye, well, I have sent it to you. I'll just start.
You
I'll continue
start.
with it. And
Yeah.
whenever you get it, you can start sharing.
Yeah,
perhaps.
yeah.
So the statutory interpretation of the Evidence Act, let's discuss the section 3. So the evidence also includes all statements which the court permits or requires to be made before it by the witnesses in relation to matters of facts under inquiry. Such statements are also called oral evidences. Secondly, all documents produced for the inspection of the court are called documentary evidences. This interpretation is not exhaustive, which we will come to later when we talk about electronic evidences and why a certificate is needed for them. So this does not cover material objects like photos, weapons used in murders, bloodstained clothes, etc., which are admitted in practice. So these are not going to be part of documentary evidences. Court is also not concerned, it does not concern itself with the method by which such evidence is obtained, which was observed in Pushpa Devi versus M.L. Wadhwa. The tape recorded conversation is held as documentary evidence. Now, there are also later judgments on it in which the act has evolved, where the Supreme Court has held different viewpoints as far as tape recorded conversations are concerned. Dog tracking evidence is held to be scientific evidence, which was held in Abdul versus State. Now, we'll just have a little overview of Evidence Act, then we are going to discuss case laws. So the objective of law of evidence is the cardinal principles of law of evidence. Evidence must be confined to the matter in issue. Hearsay evidence must not be admitted, though in certain circumstances it is admissible. Best evidence must be given in all cases. Facts judicially noticeable need not be proved, which is under Section 56. Facts admitted need not be proved under Section 58. So let's go to some of the more important sections of the Evidence Act that we usually deal with. Most of them are going to be related to dying declaration. They will be in respect to property. Now, with the IT Act and the amendment to the Evidence Act, we also have sections relating to electronic evidences. And also there is a judgment that came last year, which was about the WhatsApp chats and their admissibility in the courts. So let's begin with the forms, the basics of dying declaration. It is covered under Section 32(1) of Indian Evidence Act. It defines dying declaration as a statement written or verbal of relevant facts made by a person who is dead. It is the statement of a person who had died explaining the circumstances of his death. Dying declaration is based on the maxim, a man will not meet his maker with a lie in his mouth. Nemo moritus presumitur. Matthew Arnold said that the truth sits on the lips of a dying man. The law presumes that the dying person will not lie. And dying declaration was borrowed from the US laws. It was not part of the common law system. So I'll just bring up some of the cases for dying declaration. In Jayamma versus another, and another versus state of Karnataka, the accused allegedly doused the deceased Jayamma in kerosene and set her on fire after a heated exchange of words. The Honorable Supreme Court held that the narration of events in the dying declaration was so accurate that even a witness in the normal state of mind cannot be expected to depose with such precision. Those were the exact words they held. So although it stated that deceased was questioned by the police officer, yet the purported dying declaration is not in question and answer format. There was sufficient evidence on record that the victim had been administered highly sedative painkillers owing to 8% burns. So the injuries suffered by the victim were all on the vital parts of the body. So it can be legitimately inferred that she was reeling in pain and was in agony, was given high painkillers, and the possibility of her being in a state of delusion and hallucination cannot be completely ruled out. So the accused were acquitted because they felt that the victim was not in fit mental state to have been giving such an accurate dying declaration, which could be admissible. Then I'll just talk about the next part of dying declaration that we will deal with are forms of dying declaration. The best example for forms of dying declaration that we all are aware of is the case Mukesh and another versus state of NCT. Now, this was the infamous Nirbhaya case. In this case, there were 3 dying declarations that were made. The first dying declaration was given to the doctor, second to the subdivisional magistrate, which was in detail. And the last one was recorded by the executive magistrate, where it was recorded with the help of gestures and nods, where the executive magistrate must have asked questions and the victim had gestured or nodded in yes and no forms for them to record. And this was also accepted by the Honorable Supreme Court as a valid dying declaration. And this becomes actually a landmark in as a case where 3 different types of dying declaration were made. So this says that a dying declaration is an important piece of evidence, which, if found veracious and voluntary by the court, could be the sole basis of conviction. However, the court, while admitting a dying declaration, must be vigilant towards the need for compos mentis certificates from a doctor, as well as the absence of any kind of tutoring. However, it should also be noted that in certain cases, the court has admitted dying declaration even in the absence of the compos mentis certificates. So there's another case, Sumit versus State, which was in 2021, where a divisional bench of Delhi High Court upheld the conviction of the accused husband under Section 302 of IPC, where the husband had set the wife ablaze. The bench observed the dying declaration of a person by itself may be sufficient to find accused guilty. And if the statement is reliable and credible, it does not even need to be corroborated. Based on the Supreme Court judgment of Kushal Rao versus State of Bombay, which is another very important judgment and often cited. So we have discussed the credibility of dying declaration and the forms of dying declaration. Now let's get on to the admissibility of electronic evidence. This again is another important issue which is coming more so with the advent of technology and how it has intruded our lives. And it is being used a lot in contract cases as well, which we have seen in the Quippo case. So under the Indian Evidence Act, Section 65B prescribes a distinct framework that governs the admissibility of electronic evidence. There have been multiple litigations over the scope and ambit of Section 65B, with divergent views taken by the Apex Court. So there was a 3-judge bench of the Honorable Supreme Court in Arjun Pandit Rao Khotkar versus Kailash Kishan Rao Guratyal. So this is the Arjun versus Kailash case, as often is referred to in law schools and otherwise, where the court had clarified the interpretation of Section 65B. So the confusion had arose over the scope and ambit of Section 65B, as inconsistent views had been taken in 3 earlier decisions of the Honorable Supreme Court. The 3 earlier decisions were Anwar PV versus PK Bashir. That was the Anwar versus Bashir case. Then there was the Shafi Muhammad case. And there was also the Tommaso Bruno case. So in these 3 cases, there were different viewpoints as far as electronic evidence is concerned. So we'll just have a cursory look at the interpretation that the court held and how the honorable judges got to their own concurring and dissenting judgment. So under Section 65A of the Evidence Act, the contents of electronic records have to be proved as evidence in accordance with the requirements of Section 65B. Both Sections 65A and 65B were inserted through the Indian Evidence Amendment Act 2000, and they both form part of Chapter 5 of the Indian Evidence Act, which deals with documentary evidence. In Anwar versus Bashir, it was clarified that as Section 65 begins with a non-obstant clause, it forms a complete code for the admissibility of the electronic evidence. Under Section 65B(1), any information contained in an electronic record which has been stored, recorded, or copied as a computer output shall also be deemed as document and shall be admissible as evidence without further proof or production of the originals, if the conditions mentioned are satisfied. So what gave rise to the conflicting interpretation is the provision in 65B, which states that if the electronic evidence is to be used in any judicial proceeding, a certificate shall have to be produced, which identifies the electronic record and gives particulars of the device involved in the production of the electronic record. This certificate shall have to be signed by a person occupying a responsible official position in relation to the operation of the relevant device, or from a person who is in the management of a relevant activity involved. So this is the reason why it comes under documentary evidence, because it needs all the certification. But we will see a rather conflicting view to this part of electronic evidence when we discuss the judgments on WhatsApp. Anyhow, the signature shall also be evidence of the authenticity of the certificate. Section 65B subclause 4 also mentions that the contents of the certificate should be stated to the best of the knowledge and belief of the person stating it. So let's discuss the analysis of the EPIC scores in this case. In Arjun versus Kailash, the court had to educate on an election petition which challenged the election of Mr. Arjun Pandit Rao Khotkar to the Legislative Assembly from his constituency on the ground that the nomination papers were filed after the stipulated deadline. The respondents wished to rely on video camera recordings to prove that the candidate had filed his nomination after the stipulated deadline. The Election Commission produced CDs which contained a copy of the video camera recordings in accordance with the direction given by the High Court. However, the necessary certificates were not produced in accordance with the Section 65B by the Election Commission, despite multiple requests made by the petitioner. So during the cross-examination, an officer of the Election Commission testified that the video camera recordings were authentic. Based on this testimony, the High Court admitted the evidence of the video recordings, even though the certificate in accordance with Section 65B had not been produced. The High Court held that it was satisfied that there was substantial compliance with Section 65B, as a competent officer had testified that the video recordings were authentic. In this scenario, the Honorable Supreme Court had to interpret Section 65B for determining the following issues. So there were 2 issues that were made out of it. The first was whether the certificate under Section 65B must be produced even when an original record of the electronic evidence is available, or does it have to be given only when a secondary record of the electronic evidence is produced? The second was whether compliance with Section 65B is mandatory even in a situation when it is not possible to obtain the certificate from the competent entity. So the lead opinion was delivered by Honorable Justice Nariman, and a concurring opinion was delivered by Justice Ramasubramanian. So Justice Nariman noted that Section 65B differentiates between the original electronic record, which is contained in the computer in which the information is first stored, and the secondary copies that are made from the primary electronic record. So he was relying upon the original electronic record, and that is going to be accepted. For instance, in the present case, the original electronic record would be the computer on the of the election commissioner, in which the video footage is first stored. The CDs where the content of the video recording were copied, that shall constitute secondary copies of the electronic record. It was held that the certificate under Section 65B shall have to be obtained only when the secondary copies of the electronic record are produced before the courts. So there was no need for the certificate before that. Anyway, production of a certificate shall not necessarily, would not be necessary even when the electronic record is produced. The original electronic record can be used directly as evidence if the owner of the computer, tablet, or even a mobile phone steps into the witness box and establishes that the device where the information is first stored is owned or operated by him. Operated in the cases where the person is not the owner, say where we are using CCTV footages. So if the computer where the electronic record was first stored happens to be part of the computer network or a computer system as defined under the IT Act, and it is not possible to bring such a network or a system physically to the court, then secondary copies can be produced along with a certificate stipulated by Section 65B. So this was Justice Nariman's point. Justice Nariman further agreed with the view taken in Anwar versus Bashir, which held that Section 65B is a complete code in itself for the admissibility of electronic evidence, and it shall not be affected by other provisions of Evidence Act. It was held in Anwar versus Bashir that if an electronic record as such is used as primary evidence under Section 62 of Evidence Act, the same is admissible in evidence without compliance with the conditions in Section 65B of the Evidence Act. Justice Nariman clarified that this dictum should be read by omitting the words under Section 62 of the Evidence Act. This is because Section 65B is a complete code for electronic evidence, and it shall supersede other provisions such as Section 62. So often we have seen where the cases have mentioned both, because sometimes people, when they're not aware of the latest developments, might mention both. We need to know that one of them has to be eliminated, that is Section 62. So Justice Nariman implied here that it is not necessary to refer to Section 62, as 65B itself distinguishes between the original electronic record and the secondary copies of the electronic record. So this overrules Tommaso Bruno and also the Shafi Mahmood case. The court stated that the decision in Tommaso Bruno was per incurium, as the court in Tommaso Bruno concluded that Section 65B was not a complete code. So this later judgment by Justice Nariman had overruled that one, and it said that without making any reference to the earlier decision in Anwar versus Bashir. So Justice Nariman also stated that the decisions in Shafi Mahmood had misinterpreted the law, while concluding that Section 65B is merely a procedural provision, and the requirement of obtaining a certificate can be dispensed with when the electronic device storing the records is inaccessible to the person who needs to obtain the certificate. So he clarified that this is a code in itself, it is not procedural at all. So until a comprehensive review of the legal framework dealing with electronic evidence is undertaken, the decision of the Honorable Supreme Court in Arjun versus Kailash will ensure that the compliance burden under Section 65B is partially reduced, with the court holding that such certificate has to be produced only when secondary copies of an electronic record are relied upon by any party. We should also note here that this provision of the section 65B that we have is actually borrowed from common law countries. And this section is actually repealed in the Evidence Act in UK, from where we have borrowed it. So the next that I would love to discuss in the A to Z Infra Services versus Quipo Infrastructures Limited, now also known as the Vyom Infra Ventures. So in this, the Honorable Supreme Court had discussed the issue related to WhatsApp chats. So the question arose was, there was a transaction between the two companies, and there was some 8 crore rupees involved, and there were WhatsApp messages, there was if there was escrow amount or not. So in this, the question that arose was, the Indian Evidence Act requires that any electronic record be presented in the main form of evidence, but that the document is proven by primary evidence before it may be admitted as evidence. The courts have time and again answered the question of whether WhatsApp chats have any evidentiary value or not, and have emphasized and ruled that WhatsApp chats cannot be used as evidence without a certificate under Section 65B of the Evidence Act. So this was fairly recent. So the bench, consisting of Honorable Chief Justice Ramanna and Justice Bopanna and Justice Shrishikesh Roy, I think, they had said that the evidential value of WhatsApp messages these days is questionable. They actually asked, what is the evidential value for the same? Anything can be created and deleted on social media these days. We don't attach any value to the WhatsApp messages. Prima facie, they were not satisfied with the High Court direction for depositing the money in an escrow account. They considered that the admissibility of WhatsApp messages in such cases is often forced, and because everything on social media is constantly being edited, they were not willing to go by it. So they did not purport the admission of WhatsApp messages. And they also said that, such cases can go before an arbitrator, and parties there would be bound by the arbitration award. So, whether the payment has been delayed, or it's questionable whether the payment was made or put in an escrow account. So they said the admissibility of WhatsApp chats were not at all needed. Matter like this can directly be referred to for arbitration, and it can be decided thereupon without the need for such evidences. So that is where, in that case, the admissibility of WhatsApp chats was completely ruled out. So I think we still have time to discuss a few more. Right, sir? I'm checking with you.
Ma'am, yes, ma'am.
Okay.
You are very true, ma'am. Because, the electronic evidences are really right now, in the case of this Aryan case also, the electronic evidences do not have any credibility, because, as per the Solicitor General has argued in this particular matter of this Aryan Khan, and Rastogi sir has stated before the Bombay High Court that also that admissibility, if the message has been transferred, it is not that the sole evidence for that particular message, and the burden lies on the person that he has to prove before the Honorable Court that whether the there is an evidentiary value of that particular message, is whether the credibility is important, is there or not, the gravity is important or not, isn't it?
Right.
Yes, madam, you can proceed, ma'am.
Right. So we will discuss another section 17. There was a case law called Bharat Singh versus Bhagirathi. It was a suit for the title of the property on the basis of existence of a joint family. The women contended that the husband was not a part of the joint family at the time of his death, but he was separate. She had, however, admitted in certain documents about the existence of the joint family, but she was not confronted with those documents when she was in the witness box. The Honorable Supreme Court held that admissions have to be clear if they are to be used against the person making them. They are substantive evidence by themselves in view of Section 17 and Section 21 of the Indian Evidence Act, though they are not conclusive proof of the matter admitted. The admissions duly proved are admissible evidence irrespective of whether the party making them appeared in the witness box or not, and whether the party, when appearing as witness, was confronted with those statements in case the party made a statement contrary to those admissions. The purpose of contradicting the witness under Section 145 of the Indian Evidence Act, which provides for cross-examination as to previous statements in writing, is very much different from the purpose of proving the admission. Admission is substantive evidence of the fact admitted, while statement used to contradict a witness does not become evidence and merely serves the purpose of throwing doubt on the veracity of the witness. The weight that is to be attached to admissions made by party is a matter different from its use as an admissible evidence. So this was all about veracity of the evidence, as I've read out from the judgment, excerpts from the judgment also. We cannot throw the burden on the witness at the last minute. We have to check the veracity for that. Let's discuss a few more cases and then we can just do some question answers. So another interesting case law was, I'll just share some latest ones on the dying declaration, because that is one that we come across often. And there was one more thing that I was just discussing with one of my seniors, and I would love to share. That is, we were discussing if dying declaration and dowry killings are actually related to the geopsychology of a place, or is it a socio-cultural stigma that we suffer from. And often it is considered that a lot of these dowry killings that are happening are now going to be in the ambit of geopsychology instead of just a socio-cultural problem that the country faces. So I'm going to take through a brief of overview of dying declarations, and then we'll do some question answers. So I'm just pulling up 1 minute. I'll just. So we'll just, since we are discussing more on evidence, we'll just talk about who all are authorized to record a dying declaration, which often comes. I have discussed it in Mukesh and others versus State of Delhi. However, often what I also come across this question is, if only a magistrate is entitled to record a dying declaration. Over the years, it has been held that no, it's not just the magistrate who is entitled to record a dying declaration. It can be given to anybody. In fact, last year I came across a case where the dying declaration was not made to any person, not to the doctor, not to a magistrate, not to a subdivisional magistrate, none of that. It was recorded on video at the hospital by a stranger. This case happened in Etawah in UP last year, September or October sometime. So the question that arose was whether the police will consider that video recording as a dying declaration. Will it come under Evidence Act? And yes, it was admissible. So this brings us to the question of who all can record a dying declaration. So it was in state of Karnataka versus Sharif in 2003, the Honorable Supreme Court held that there was no requirement of law that a dying declaration must necessarily be made before a magistrate. Certification by a doctor is essentially a rule of caution, and therefore the voluntary and truthful nature of the declaration can also be established otherwise. There are instances where a magistrate was not present and the declaration was made to others, even in form of just a complaint to police officer. In fact, there have been cases where dying declaration has been recorded as a letter sent by the woman to her family. In fact, I might have that. I don't know if I have, or maybe I'll forward the case law to Rajesh sir and he can share it. So there was another case of Paras Yadav and others versus State of Bihar, where the court held that lapse on the part of investigation officer is not bringing the magistrate to record the statement of deceased should not be taken in favor of the accused. So yeah, we know that it is investigation officer's responsibility to bring the magistrate, but if he doesn't know, which we often see in I mean, when we are looking at smaller towns, we know that even now, even today, the police does not follow the proper procedures. We also notice that there are a lot of arrests on cases which are bailable because somehow the amendments don't reach the furthest part of the country. Anyway, so the court further held that a statement of the deceased recorded by a police officer in a routine manner as complaint and not as a dying declaration will also be treated as dying declaration after the death of the victim. If they have died through injuries and have relied upon evidences of the prosecution witnesses, and it clearly establishes that the deceased was conscious and in a fit state of mind to give a dying declaration. Under the credibility of dying declaration, let's discuss state of MP versus Dal Singh. The court explained the legal position while awarding life imprisonment to a man and his parents for burning his wife to death. So what happened was that the victim alleged that her mother-in-law had poured kerosene on her, her father-in-law had set her on fire, and the husband had closed the door. So technically, he was not the person who poured the kerosene or set her ablaze, but he was party to the crime. In their plea, the accused contended that there were two statements of the victim, one recorded by an executive magistrate and another by the IO in the form of FIR. And there was contradiction as to who had set her on fire. The trial court held the conviction can be made solely upon dying declaration and provided that the same is to be found trustworthy. However, in this case, the deceased had 100% burn marks. So she would not have, in all probability, been in a situation, in a position to make such a statement. Additionally, in the absence of a certificate provided by the doctor, the dying declaration could not be relied upon, as she had died as a result of such injuries on her person and had traveled for 10 kilometers from the place of occurrence to the police station. So this was what the trial court had held. The Honorable Supreme Court, however, rejected all these arguments, stating one cannot be expected in such a physical condition to give the exact version of the incident. The Honorable Supreme Court had said that the law on the issue can be summarized to the effect that it does not provide who can record a dying declaration, nor is there any prescribed form or format or procedure for the same. And the person who is making the dying declaration, one must just be satisfied that the person is in a fit state of mind to make such a statement. However, one should also believe the fact that a person is not going to give full version, and that is why the trial court's judgment was not upheld later, and the Supreme Court had rejected all the arguments made in that case. So in Ram Bihari Yadav versus State of Bihar, it was held that the dying declaration need not be in the form of question and answers. When we start studying Evidence Act, or when we used to, that was told to us, I'm sure Rajesh sir would agree with that. We were told that it has to be in question answer form. Over the period of time, the rulings have changed and it is held, it does not need to be in question answer form anymore. It can be in various other forms. Now we know that it can also be recorded on the phone and that will be admissible. So in some cases, we see that neither the format nor the length of dying declaration which corroborates, but the circumstances and the evidence of the whole case point to the admissibility of the dying declaration. I have already discussed Jayamma, where it was held that it looked like it was false. And then we have also seen the ones where the Supreme Court has held that irrespective of what the state of the person is, it will be considered a dying declaration. In Suraj-Deo Oja versus State of Bihar, it was ruled merely because a dying declaration is a brief statement, it is not to be discarded. On the contrary, the shortness of the statement itself guarantees that it is true. So it does not need to be a lengthy statement. Of course, when a person is suffering from burn injuries or any other kind of injuries, usually we come across burn injuries, they are not going to be in a state of mind to give an elaborate story. There will be brevity, and brevity means true. Since I have cited examples of cases from Bihar and UP, so I would like to again bring us back to the case, the new legal development that, so to say, that we are getting into is the geopsychology and crime. And this, of course, goes back to 1912 when this author had written about the socio-cultural situation of a place and crime. So now I think, not now, but another 10 years, we will be using geopsychology in criminal investigations. It might actually be taught in law schools for all we know. So let's just trace back in brief, how did the various forms of dying declaration came into existence in India? Because this consists a major part of Evidence Act, and we, especially in North India, come across lots of cases which deal with dying declaration. So the oldest known case that we all have studied is Queen Empress versus Abdullah, where they had cut the throat of the deceased girl, and because of that, tongue of the deceased girl, she was not able to speak. So she indicated the name of the accused by her hand gestures. And the full bench of Honorable Allahabad High Court, then in 1885, held that if the injured person is unable to speak, he can make dying declaration by signs and gestures in response to the question. And this again, we have seen later in Nirbhaya case, when she gave her final dying declaration. In state of UP versus Hari Mohan, the victim wrote a letter to her father to take her home. Otherwise, her mother-in-law and brother-in-law would murder her. This was 2 days before the actual murder took place. So she had sent this letter by post. So it was established in this case that the letter can also be considered a dying declaration given by the woman. Often we come across now in a lot of cases of domestic violence and even divorce cases where DV Act is used. If a person comes and says that she's suffering from domestic violence, we send emails to your family, send WhatsApp messages to your family, because this will all be part of your evidence. And we use it as evidence in divorce cases, in domestic violence cases. And God forbid somebody is injured, this will again be considered as case, and God forbid there's any case of dowry killing, but these are again evidences. So we have already discussed the other one, Mukesh and others, and multiple dying declaration. There was another case in Haryana, which was Sandeep and others versus State of Haryana, where the first dying declaration was given to the police officer, and there was a subsequent dying declaration given to judicial magistrate, which lacked certain information that were given earlier to the police officer. So after referring to the two dying declarations, the court examined whether there was any inconsistency between the two dying declarations. After examining the contents of both the dying declaration, the court held that there was no inconsistency between the two dying declarations. And there were certain features that were not mentioned when it was recorded by the judicial magistrate, but that did not make both the dying declarations incompatible. So more and more it has been held that the corroboration and the corroborative value of dying declarations in evidence is not, one does not have to be a stickler to it. There can be differences, but it is where the judicial mind has to be used, that has to be applied to see and discern if both the dying declaration are matching or not. And also in Evidence Act, this was this was before the summer holidays in the Honorable Supreme Court. This is an interesting case. I won't be able to take the name, it's still sub judice, but the father had murdered the mother, and the custody of the child was with the grandparents. The father wanted to meet the child, but the Honorable Supreme Court held that since the child is the witness, and under the Evidence Act, they will not allow the child to be allowed to meet the father, because they will be tampering with his emotions, which will come under tampering of evidence. Of course, this matter is still sub judice, and it should be decided by end of this year. But that will again come across as a wonderful case, provided it gets decided in the favor of the victim and not in favor of the father. Anyhow, so that would be all for today for Evidence Act. Of course, we focus more on dying declaration because of the nature of the crime that we come across so often, and electronic evidences because we deal with it so much in this age and time. So over to you, Rajesh, sir.
Ma'am, it was very fantastic session, and you are updated with many case laws on 65D. Then you are also elaborated on section 32. You are also elaborated on the electronic signature. See, basically, as per the today, I am also teaching that particular things. So you know that the electronic signature is admissible when the authority will give the consent. If the authority is saying that yes, this electronic signature is valid, then it can be a relevant one. Because today some of the students were asking that, sir, on what ground you will say that the signature will be relevant? So I told them that if suppose the authority, let us suppose I am working in organization, let us suppose I am working in the Par University, and my president will authorize to any authority to have a signature on certificates like that. Okay, so it becomes a relevant one. But if suppose certain certificates which were made without the consent of the authority, so it is not admissible, and if it is said that a fraud certificate has been shown, then the court can take court has a discretionary power to take the action on that particular thing. So, madam, we have certain 1-2 questions from the students. We are not going to ask any more questions. We have certain questions. So, ma'am, one question is that that certain rules like army rules and these other rules are there. So that judicial notice as per section 57, that court can take the judicial notice on any. So ma'am, on because there are various rules in our country. So how we can take this that any act or any judicial decision is said to be relevant, because sometimes sometimes the decision were overruled also. So what is your take on this, ma'am? Ma'am, your voice is you are mute, ma'am. Yeah.
So judicial notice can be taken upon request of a party that submits the fact. However, it was also held a couple of years back that the relevant facts that are admitted under judicial notice are accepted by the court even without producing a witness. And this rule often is used in the simplest and obvious facts that are considered to be common sense and need not be proved. Of course, in bigger facts, it will not be considered. But for, the simple facts, they will say, yeah, you don't have to. It will be accepted even without producing a witness. And we come across that all the time before the matter reaches, of course, even High Court in trial, we come across it.
Yes, ma'am. Ma'am, one more thing that as per section 58, it is said that the fact admitted need not to be true. But madam, certain times, the person has a pressure and he has taken certain money from any person to give the statement that yes, I have committed this mistake. But actually he was not committed the mistake. So on that scenario, what is your take on this, that what court has to, whether the court has a discretionary power to produce the evidences if the person is saying lying, he's admitting unnecessary because he has not committed, but his condition was so that he is just accepting that he has committed the crime. So what is your take on this now?
So it has been said that the facts they need not be proved. That the court has, of course, held that there's no need to prove it. But again, depends upon, of course, it depends upon the court. If
So it is a discretionary power of the court.
yes, exactly, it's a discretionary power. So of course, it depends upon the court.
I also, because some of the students were asking in my class that, sir, how it can be possible. So I said that, that there is a discretionary power. But if suppose certain pressure is there on someone is forcefully saying that you have to say this statement and you admit this and certain amount was given. So if court able to understand that yes, there is a problem and he is unnecessary and forcefully saying this, so court has a power to say to the person who is accepting to produce the evidences that you have committed, you have to prove this case. So burden lies on that particular person, isn't it?
So of course, the court can definitely, because as we know it's a discretionary power, the court can definitely ask for it to be proved. But of course, we know that no fact need to be proved. So that is how the lawyer will approach the court and say, okay, of course, it does not need to be proved. But of course, it's a discretionary power and can be
asked. In the civil cases also, when the pleading
right.
is
yes,
done.
It comes often in civil cases we come across it. Even in property disputes we come across it.
Yeah. So, ma'am, it is very fantastic session by you, and really we enjoy the session. You have incorporated. Please share your slides to me so that I can share to my students of that particular PPT. And we are very much thankful to you, ma'am, on the behalf of Parul Institute of Law. I am thankful to you. So I am also thankful to Brijesh sir and Millie Gupta, who is the co-coordinator of this program, who is also involved. She is joined recently in our Parul Institute, and so she is on the learning stage, and she is also doing very well for the betterment of our institute. So I am also thankful to her, and Mr. Gagmeet Singh, who is still in this because he is preparing for the certain judiciary examination also. So it is, it is a valuable lecture by you, ma'am. So thanks a lot, madam, not taking more time.
So, much,
so we are closing this session. And thanks to the Brijesh sir, who has given the live coverage. So on this note, we are closing this session. Thanks you, ma'am. Thanks a lot.
Thank you.